Thank you very much, Mr. Miller. Mr. Chair, sir, thank you very much. And I'm sure that you will give me friend treatment as far as time is concerned. Please give me friend treatment as far as the time. Thank you very much, GIPC, for having me here. Thank you, Dr. Agarwal. I have been in this practice of intellectual property and specialize and focus in interface between intellectual property rights, trade, and competition. Where it comes to trade, we talk about exhaustion of rights and parallel trade and IPR. But today we are talking about interface between competition, intellectual property rights and competition. And for that reason, we'll try to see where lies the similarities between intellectual property rights and competition. Are there any similarities at all? Or where are the conflicts? What I see here is one model, a business model, where you have innovators innovating and trying to exercise their rights that they have gained through their intellectual abilities and definitely reap benefits on them. There is another business model where perhaps small, micro, medium-sized enterprises come in and then they realize that they may not be able to filter into the market and think about a different business model, which is a dissemination business model, technology dissemination business model, and that's based on the licensing model. They realize that we will scale up, but go on lower royalty and make sure that most of the people, if not all, can use the technology and gain from the technology. That's the two different business models. We need to make sure that whether it is the regulators, patent or IP regulators, or the competition regulators, do not breach their independent jurisdictions and touch upon the innovation, touch upon the way that the innovation can promulgate and disperse. This is the basic fundamentals on which I will talk. I have to give a disclaimer that I have nothing really innovative after all the eminent speakers, very distinctly guided by the chair moderator, have already disclosed. What I will do is try to lay the fundamentals, now that I'm wearing the hat of the navigator, and try to see what are the areas that cause the problems, what are the areas that we need to take into consideration while navigating. First of all, I do have certain reservations as far as my opinion is concerned. IPRs, we usually say, are monopoly rights, but I typically would not say it is a monopoly right, because monopoly is a market condition. If you have exclusivity and there are alternatives, you may not have monopoly. So there is an exclusivity which is given through the IP rights that can lead to a monopoly situation, but not necessarily that this is a monopoly. That's my understanding. We can discuss that. Competition, antitrust laws ensure free and fair market conditions so that the competition can thrive. Now the point, what happens, the point where there are clashes is when one of the domains overreach and go out, and we had elaborate discussions on that as to where the IPR, where would be the ambit, where would be the thin line dividing the IPR and their rights and going beyond and violating competition. That's where the issue comes in. Already I have touched upon some of the basic, I would say, errors that we consider. First is that we consider all IPRs establish monopoly, and then we decide and we think that the moment there is a monopoly, there is market dominance, And then when there is market dominance, obviously the player would like to capitalize monetarily on that, and so there would be an abusive dominance. And then when we go into deeper, I've jumped a bit. When we go deeper, we'd say that, okay, when we have grant-back licenses, they are all abusive. There is, per se, the grant-back scheme is erroneous. And then, obviously, again, the other one, I'm gradually moving into the debate when we are, the debate that we are having, is that portfolio licensing per se is a tie-in agreement and should not be. These are, if we have this in mind and then we proceed, I think it would be erroneous. The fights, typically the litigations, we see whether in India or outside, there would be certain distinctions. In India, there may be some reasons which push it more. In other jurisdictions, it might be slightly different. The point which I want to raise here is a prospective licensor once, when he has decided that this is my technology which I have invented and I'm ready to put it on the market and license, the ultimate aim is proliferation, and the ultimate aim is monetarily to make sure that the license happen. And the prospective licensee, when the licensee is interested in taking the license and work on the patent, there is an understanding that the license will be negotiated and completed and closed. But in between, the discussion where it gets derailed quite often is because of the licensing norms, because of the royalty rate. And those are negotiating issues which obviously are the tricky ones. Now, in certain situation, if we look at from the perspective of where it goes beyond that thin line which differentiates between the competition adjudicator and the IP adjudicator to look into and check whether there is any violation or not, the competition angle would look into the possibility of